Yes, welcome to the No State Project, live from the fortified compound in Mesa, Arizona. It is a beautiful day in the Valley of the Sun. Glad to be with you here for 3 hours of Anarchy Radio from the fortified compound on LRN.FM, the Liberty Radio Network. Also streaming live on my YouTube channel. It is No State Project, of course. And I appreciate the support of the big broadcast. This show being brought to you by Don, Bill, and Dan in New Hampshire. I do appreciate the support. And if you'd like to be able to support the big broadcast, you can do so at markstevens.net. You could just check out my sales page and be able to do that. And you are able to even donate $1, which is still cool. Every time I hear the news and they talk about Yemen, the first thing that I think of is Channel being back. All the problems happening in Yemen, has Channel finally gotten out? But you want to join me on the big broadcast? Actually, I've got somebody who's going to be joining me. I haven't connected to the caller line, but I'm glad that he called in. He's offering some more support to show that Juan Galt is not on point. So I'll have him join us in the next segment. But for those who want to get in the queue for after that, it is 218-632-9399, 218-632-9399. The passcode is 2020 with the pound sign. And a lot of stuff still, it seems like the collections department at the Franchise Tax Board don't want to speak to me anymore. So the line was busy for 3 days straight. And I just called every hour or so just for the hell of it to be able to document that I wasn't able to get through. But I can definitely talk about that. If you are in the San Diego area, I'm sorry. I should have been there doing a live broadcast from – I've always done the live broadcast from Libertopia there in San Diego. Not able to make it. Still shouldn't be a reason why you should not check out the festivities there at Humphreys by the Bay. So it's only half over. So but it ends late tomorrow night. So if you're in the area, check it out. Hopefully the guys had fun with the Blues Jam. I was not able to do that, but hey, I'll do what we can to set up another Blues Jam and do the show live in Oceanside. So maybe we could do that next month. Again, if you do know someplace here in the East Valley, Mesa, that has an open mic and would be open to doing a live broadcast of 3 hours of Anarchy Radio, let me know. You can always reach me at markstevens.net. And for those people who are watching the YouTube stream, I guess what I can start doing is markstevens.net is how you can contact me. The information is right there. Every show I have for the banner there. Oh, I got to get that the hell out of the way. I have the banner going, and so it's markstevens.net. You go to markstevens.net. There's a contact link, and all the information is there to be able to connect with me. Every single show, there's somebody, I need help. How do I contact you? markstevens@mail.com. And Frank Rizzo 3 on Skype will get you through there. One of the things, let's see, someone's asked me if I try the Super Overdrive pedal by Boss. No. I actually have a pretty damn nice Fender FM 2x12 that has kind of a factory default of, just choosing, I'm not going to work today. Oh, I lost my. Yeah, it's going to be one of them. Okay, so unfortunately now that it has not been working, so I've been stuck using an old crate. But I'll talk about music another time. I'm hoping that maybe it's a quick fix. Somebody here, I could pull the face off of this, and maybe it's just the input jack, which is why it works only intermittently. But boy, when it does, so that's a nice amp. Okay, so somebody, all right, Jan, of course, asked me again to discuss risk management and how you go about doing that. Now, I will be posting, or I have making available to those who get the Motion template package, the initial document for risk management. I think it's important to try to limit the damage, if possible, to get risk management and the city council, the county commissioners involved, and let them know you got a judge here. Some lawyer is unhinged. So let them know in advance and use your facts See, we do things based on the evidence here. The No State Project is based on the evidence, where the evidence dictates the narrative, not the other way around when you're talking people like ICBM Catcher and critics who want the evidence to conform to their narrative, or they just say, yeah, well, we don't need evidence. Might makes right. So how about fungal, Mark, and your logic and your reason, your ethics and all this? We don't give a damn about it being ethical. Might makes right. There are no ethics. There is no morality. There is no point unless you're willing to pick up a gun and shoot every, agent and overwhelm them with power. Might makes right. You're a child playing with this nonsense, these silly childish things like ethics and morality. So anyway, let them know in advance. And hey, as long as you've got the evidence, yeah, you can back up that the judge has a judge and the prosecutor who are either city employees or county employees, and they are covered by risk management. Don't let them kid you. They are. So we let them know in advance, so that maybe the fact that the judge's name is being connected with unhinged and unfair, immoral, okay, and has no basis, and that he has no connection to basic principles of right and wrong, let alone due process due process requirements. And so maybe that they could turn around, they could say to the prosecution, this is a risk to the county that could be significant in money and affect your budget. If the judge isn't going to go by due process, you should withdraw. It's not fair. See, that's the thing. It's supposed to be about due process, that they're supposed to give you a fair trial, and that the prosecutor is not supposed to just convict. The prosecutor, I know this is laughable, the prosecutor is supposed to help ensure due process also. They have an obligation to ensure due process. And if there is a situation where the judge is being grossly unfair, they can object also. Just like when the monster Cheryl Hardy ordered a psych evaluation on Bao. The prosecutor should have objected, as well as Bao's attorney, because that breached protocol. The judge is not supposed to do it unilaterally. I had, I haven't done that yet. The court administrator there for the criminal court system told me, judges, it's against the policy. Judges are not supposed to do that unilaterally. They have to do it on the recommendation and evidence from the prosecutor or defense counsel. So here, these two lawyers, yeah, you want to sit there and sing the praises of lawyers. Here is an example of two lawyers allowing a third lawyer to order a psych evaluation, breaching policy, having no evidence whatsoever. And neither one of them thought, hey, as officers and counsels of the court, we're supposed to be obligated to due process. Maybe we should object. Oh, but that's right. When you become a lawyer, you take your spine off and you leave that at home. Well, one of your homes, anyway. No one's really going to accuse attorneys of being valiant protectors of right and wrong. No. No, not at all. Not at all. So that's what we want to do first. Maybe I'll have to I'm going to have to just do a separate video, because I'm going to be bringing somebody up here, so I can't finish the risk management. So if I do finish in this video, I'll have to just cut those segments together. But actually filing the complaint or risk management, it would be nice to then, when you file your claim, so let's say it's Calgary, and you can just go to Calgary's website, the municipal corporation, and they look for risk management, and they may have a form that you're probably going to have to use. You have to put your facts in. You could put your facts in an addendum, but they're going to want you to use their form. So use their form. And in there, you could point out, I let the county know. I let the city, the risk management, as well as I let the county commissioners know in advance what this man or woman was going to do. And nothing was done to stop it. So talk about reckless. We'll be back in just a few moments here on the No State Project, so don't go anywhere. And I'm not going to mute the feed all the time here, but for this one, no. For this one, I'm going to have to. So I apologize to everybody listening on the YouTube stream there, but this time I'm going to have to. Hey, you beat me to the punch. You there, John?
Oh, yeah.
All right, great. Oh, fantastic. Say a few words and let me see if we got the levels right.
All right. I'm wide awake at 4 o'clock in the morning.
That's dedication. That's some dedication. I appreciate that. All right. I will mute you back up here for a moment, and we got about 2 minutes, okay?
Yeah, no problem.
All right, thanks. Yes, welcome back to the No State Project here on LRN.FM and streaming live from my YouTube channel. And I guess some of the best comments from, from the YouTube stream there, you can get this. Just go to No State Project. Hey, but if you subbed, you know when we're going live. So, yay. And so somebody's saying, it looks as it me, as it looked like Mark, was smoking, smoking a bowl. You guys could hear me during the break connecting with the caller. So no, I don't partake in the weed. No, not one of them. They're health freaks. So no, don't smoke, don't drink, no animal products. Oh, don't worry. We don't have to get into the ethics of that on this particular broadcast. But I'm guessing my caller and guest has been on the show before. He can correct me if I am wrong. He is a lawyer, although I don't. Well, he is a lawyer. He has a Juris Doctorate degree. So I'll let him explain his background. Welcome back to the show, John.
Hello. How is my connection all right?
Yeah, you sound great.
All right. I'm living in China, as you know. And yeah, I've been on the show. I've been listening to you since 2013. And the reason why I wanted to call in and I sent you an email is to give listeners some understanding of what Juan Galt was saying and why he was incorrect. And it really was quite funny as I wrote you in that email. When he said anecdotal, I lost my you know what there. I started laughing really hard. But just in case people didn't hear it or they're not sure, what day was the Juan Galt? Did he call last Wednesday? What was that date?
It was actually 2 weeks ago.
Oh, 2 weeks ago. Okay. So it's really funny because he tried to talk about logic and fallacies and all this, but he kept emphasizing red herrings. Okay. So he kept for an hour, I guess you had him or allowed him to prattle on, but he kept saying that there's no prosecutorial misconduct at the arraignment. He was really emphasizing the issue of the arraignment. And he kept saying that the ticket per se was sufficient a prima facie claim. And just to help people understand this now, and again, I went to law school at the University of Iowa 20 years ago. I graduated in 2001. I'm not a practicing attorney, but I was a law professor. And the prima facie case can only be made when you allege all the elements of a claim or all the elements of an offense when we're talking about traffic or criminal charge. And one of the elements, of course, is jurisdiction. And as we know, that Juan Galt kept saying there is jurisdiction. He ended up saying, well, his fact that he knew, to apparently which you didn't ask him, but he could testify in court is the power, right? Not a fact he has with personal firsthand knowledge. So he doesn't know any facts that satisfy the jurisdictional claim, and neither do police, as you rightly pointed out. Just to reiterate some things that people who are new to the show or haven't been listening for the last couple of years, I know what happened to you in some sense because this happens to me as a teacher. We say the same things or we discuss the same concepts over and we forget some of the key little things we say that help people understand. And 5 years ago, you had guests, I think Calvin on, you routinely went to the Catholic Church analogy and helped people understand the Catholic Church declares the whole earth is their domain. But everyone knows, and the Catholic Church concedes, not everyone is subject to their rules, their canon law, even though we are in a jurisdiction somewhere on the planet of the Catholic Church. So I know you don't say that anymore, but that might help people even like Juan Galt, understand just because someone declares you're in their territory doesn't mean their rules apply to you. But going back to more Supreme Court sightings on these rules, again, I've learned this from you, Mark. Okay, you are far more knowledgeable than any criminal law professor I could imagine. You've researched many more cases. You've had much more practice. I went to the University of Iowa, which was a school. Almost all the professors were Ivy League professors. Harvard, Yale, also University of Michigan, Stanford, Berkeley. That's, in a sense, a very small clique of people are even allowed to be law professors at major law schools because they have that pedigree. But it doesn't mean they've practiced law. Most of them haven't practiced, but some have been clerks for courts, so they only know as much as the attorneys and their own research allowed them to know. And they always say in any class you have and go to any American law school, well, if a person's in a place we call California, Arizona, Iowa, North Carolina, the jurisdiction exists. They're just assuming, just like Juan Galt. Now, they don't go to the next line and say, well, because the power, they say, well, you're physically someplace, so that means it.
Yeah.
They don't critique the concept of what does it mean to be in a state. They don't critique the concept of, well, in California, and correct me if I'm wrong, aren't all the criminal charges the people versus?
That's how they style it. So yes, they pay the people
Yeah.
of the state of California, as opposed to in
Right.
Arizona and most other places, it's just state of Arizona. I
Right.
think they do
So,
that in New
and
York also.
right, because always thought that would be funny if I had the chance. I mean, I don't want to have the chance, but if I were in California and I were charged with a crime, I would challenge I would voir dire the prosecutor, and I would say, well, are you claiming that you're representing the people? And I'd get the prosecutor to admit that I was a person, and then I'd say, well, since I'm a person, you represent me. I'm telling you not to prosecute this case, right?
Yeah,
that would just be a funny
I wouldn't
exercise.
take it that way. I do like there was an episode of Law and Order where they read the charges, and that's probably why I remember that, where they said the people that they're reading the indictment, the people of the state of New York versus John Doe. And so the defense attorney starts, all the, earning his retainer there. All the people of the state of New York against my client.
Right.
I think what I've done in that vein is to, like, the federal rules 9A, at least of the civil procedure, where you can challenge an attorney's claim that he has a client, that he's representing somebody. Now, they take it very, very serious when it's a class action. Okay. That's the only time I really have seen it taken as serious as it should be. But when they say it's the state that is their client, the only thing a lawyer has ever done is offer their bar card as if that's evidence they have a client.
Yes, I understand.
What? That's stupid.
And I just want to share for people, when I lived in North Carolina a couple of years ago, I did help people. I used your material. Thank you again for finding it, creating it, working on it, developing it. And of course, I also helped. I sent the motion in limine so people could use that. I hear the music coming up. Is it time for a break?
Wow, I'm surprised that you actually. You know what I'm going to do? I know it's late, and I value your time, so I'm going to mute the feed for a while, and we're just going to go. So the live listeners, if you go to the YouTube stream, you can get that, and you can always get all the audio at markstevens.net. So I am going to mute that up. We're just gonna burn right through that because it is very early where you are, and I can imagine that somebody like, a critic, when they hear that you're in, that you're not presently in North America, that you're actually in China, instead of trying to look at the arguments that you're raising and with evidence and support that you're giving, we'll just look at it more from a standpoint. Yeah, make these arguments in China, instead of just actually addressing the argument. That's something that I get. Not that I'm in China, but they'll say, well, yeah, you want to rain on this, and complain about all this, but let's see you complain about the government in Russia or China or Afghanistan.
Yeah.
Oh, okay. Address the argument first, and then we can get to that.
Yeah. I mean, the obvious thing here, and what you notice when you travel around the world is, there are people with guns at any place they call a border, and if you don't obey and kowtow, they will shoot you, they'll arrest you, they'll do all that. So that's what led me to be an anarchist, because you learn pretty quickly. I used to be, I guess, a constitutionalist or a classic liberal that thought, well, if you have the right kind of rules, then things can be fair and this and that. But I realized, no, you just got a bunch of thugs, and the worst people rise to the top. So,
yeah, well, absolutely. Well, let's get back to this, and we'll talk about the arraignment, because you do have a number of cases, citations that you provide as to support. So why don't you, because I didn't know if you were going to make it because of the time difference, and I'm glad that you did. So I actually have the email up over here, so I was going to go through that.
So I have it. So again, like I said, I was helping people in North Carolina, and I had adapted some of your materials, and I had, edited, cut and pasted a little bit. But I ended up developing a motion to dismiss that I think it's about 16 or 18 pages, because it really elaborated and went through every little aspect and every part of the claim that needs to be brought to show that there's jurisdiction. So there's this famous case, Todt versus the United States from 1943. For those people who want to go look it up, it's 319 U.S. 463. And it says, where's the effect of that a mere complaint doesn't it doesn't presume anything applies. So the indictment does not create a presumption of the existence of all the facts essential to guilt. And Juan Galt kept saying, you know, well, there's a prima facie case, prima facie case. Well, that would be sufficient to presume guilt if there were a prima facie case. But the Supreme Court said, no, 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 a mere indictment, or in this case, a mere citation, doesn't create presumptions. That's the problem. It doesn't create all presumptions about all the facts. Another one, of course.
Well, wait, real quick, because you also hear a state cannot convict a person without proving each element of the crime beyond a reasonable doubt. And so I didn't want to skip over what you're saying, because I think that's critically important, because you have to put together the so-called presumption of innocence and the fact that they have to prove every element beyond a reasonable doubt. And he just kept on glossing over the single most important element, being that the laws apply in the first place. So do you prove that the laws apply in the first place without even mentioning it and just assuming it, which is what they do most of the time? And if it is brought up, are you really going to go and say, well, Juan Galt, who is a stellar lawyer, by all accounts, you got to give him credit for, based on what he said, John, he is one of the single most successful lawyers in the last 40 years by his account. And I'll give him that. If he's telling the truth, he is extremely successful. But he is, no lawyer is going to go into court and say, we can prove this element beyond a reasonable doubt because we have the power and we can put the defendant in prison. They're not going to do that. So the fact is, it's completely ignored. And when you do bring it up, and I have personal knowledge of this, and it's been reported to me, so people with personal knowledge of this, that when you do bring it up, a lot of times they will actually threaten you. If you raise that issue in front of the jury, you're going to jail. If it's so easy to prove, and one is so insistent that they can prove it, at least by a prima facie, if it's so easy, why would they threaten you with contempt and in some cases carry it out and not allow you to bring that up in front of the jury?
Right. Well, the larger, well, for me, again, just highlighting and critiquing what he was saying, because, you know, he kept just beating a dead horse and kept pulling you aside from what you've said for years and what you've shown people and what you've researched. And he kept saying, you know, that they're making the prima facie case, and at the arraignment, it's good enough. At the arraignment, it's good enough. But it's, and he would say, well, the Bunkley versus Florida, the 2003 case showing you can't be convicted, that's at the trial stage. That's not at the arraignment stage. But he's still not correct, because at the arraignment, there has to be an allegation of jurisdiction, and there's no allegation of jurisdiction. And anyone who gets any kind of traffic ticket knows that there might only be a passing reference to someone being in a county or being in a city or being in a state, but there's not the extra sentence that says, and oh, the laws apply to the accused. They don't even say that. So since they don't say it, they haven't alleged that fact. They literally, if they just wrote on the ticket, person X was in Wisconsin and the laws apply to them, that would be prima facie.
I got to disagree with you there, though. I got to disagree with you there. It's not enough to just make the allegation. Prima facie, it's called prima facie evidence, and which creates a rebuttable presumption. If you just make an allegation without a supporting fact that proves, now this is where he got. I agree with the standard. That's a very, very slight standard. So what he kept on saying, and I agree, if there's even the slightest possibility. So that's why I asked him: is there the slightest possibility that just because I'm in Phoenix, that proves the Constitution applies to me? And he says it doesn't. Now, he changed and tried to say that it was the power, and then he got caught in that circular that, because I said, well, the power from the Constitution. Okay, so just saying that person X is in Phoenix and the laws apply and we have jurisdiction, I don't think that that's sufficient, because the fact has no chance of proving the proposition or the claim.
Well, again, to give a slight benefit of the doubt of a claim that you actually has good faith, a prosecutor, judge, and a cop. I think they would say with a straight face, well, the person said that the laws apply, and what people say are facts. Now, it might not prove something, but it's a fact alleging something.
Yes, but the thing is, we're looking at prima facie evidence, and the difference between facts and evidence is that evidence has some tendency to prove the claim or the proposition. And here, there's not even the slightest chance that my physical location can prove that that Constitution applies. Not even the slightest chance.
Well, not your physical presence with nothing more, I think would be the phraseology they'd want to say. But yeah, I agree. Now, just as a side note, because I was talking, whenever I get a chance, I talk to people about your material. And I was actually sitting next to a woman who claimed she was a SEC defense attorney. So, right, Securities and Exchange Commission in New York City. And she said, well, of course, all the laws apply to my clients because they've taken some pledge or something, because they have the right to be traders. So, I didn't get a chance to ask you about that, but I thought, is that one of the cases? Because I think I've written to you before when I said, well, if someone stands up and swears, I'll be beholden to all these laws. I think that might be sufficient to say the laws apply to them, but I think you would say no, that even they would say that the laws don't apply.
I would say that when it comes to like a driver's license, where just like when you want to do the SEC, that's
right.
one of the, securities are one of the most heavily regulated. So if you try to do business without it, you're going. You're gonna go to jail. So I think when it's different though, when you have a government employee who's acting in that capacity, I don't think there's any evidence to show that, but I don't think they have any standing to make that argument.
Yes,
they have an oath of office, just like attorneys swear an oath. They take an oath to that. So I think because they made a voluntary act, then they don't have any standing to make that argument.
Okay. That's reasonable. All right. If we want to go back to more of my critiques about Juan Galt, I noted the case out of Taylor versus Kentucky, 436 U.S. 485 from 1978. Mere accusation or suspicion in the indictment or complaint is not an offer of evidence of facts necessary to prove an element of the crime. So that goes back to what you said before. Just even if a police officer said, I'm alleging the laws apply, that's not a fact proving that the element of the crime, i.e. jurisdiction, exists. I do like the case that we cited, Apprendi versus New Jersey. I think that's in your material, with Clarence Thomas actually in the concurring opinion, saying that in order for the Fifth and Sixth Amendments to be adhered, the indictment must allege all elements of the crime. Now, again, this goes back to what Juan Galt kept failing to address, and I think you were just lost in the heat of the moment. But judges and prosecutors are declaring there is a fair system that has due process. They are saying that with a straight face. They really think it exists. So one of their rules is that there are elements for crimes, and according to their rulers, the Supreme Court, all the elements have to be alleged and they have to be supported with facts. And they're simply not alleging and not supporting with facts the element of jurisdiction over and over and over again.
Right. I need to address this comment, even though I've gone well beyond just responding to YouTube comments. Misty Johnson, she's saying alleging a violation of a law, like on a traffic ticket, is the same as alleging the laws apply. It's an assumption. So yes, when you say and I say it is an assumption, but even if we accept that they're not explicitly stating it, that it's just implied, the fact still remains, Misty, there's not any evidence that would support the claim whether it's implied or not, that the laws apply, because all they're giving is your physical location, and that does not prove that the laws apply to you. So if I interrupted you, I'm sorry. I didn't want. I don't want to let that go.
I made the key points, and again, just for listeners, I want them to appreciate. I was able to use your information when I was teaching law. I was in Turkey at the time, and I really started to think seriously about jurisdiction and about application of law. And I wrote an article that got accepted at an international journal, an international research journal, about the lack of jurisdiction. And I think I ended up sending it to you. It's about a 50 or 60-page article, but people can find it online. If you give me a second, I can find it, and I can tell people the reference that. But if they just look up John Calvin Jones, and I think it's I'll find the title. But again, I went through this whole thing about, there are Supreme Court cases in the United States saying that a person who was born in the United States but living in Mexico, had no connection to the United States, they still owed tax, based on monies they earned via their property in Mexico. That's the blatant level at which the United States and other governments have said, our laws apply to you. But they said over and over, it's because you were born somewhere. And the interesting thing about, if we look at American history, there were people who were born in a place called China. They lived in the United States, and the American government at that time said clearly, no, the laws don't apply to them at all because they weren't born here. We have these treaty with the Emperor of China, and the Emperor of China says they will take care of their people, their subjects, and we'll take care of ours in our respective territories, and our laws don't apply at all. Again, I gave you that note about a lot of Supreme Court cases dealing with American Indians and American Indian law. And there's actually quite a famous case. I learned this one in law school, because when you study American Indian law, the professors are quite sympathetic to the plight of the Indians. And there was a case, I think it's Oliphant, that a non-Indian was on Indian territory in state of Washington, and I think they killed somebody. And they got convicted in the tribal court, and they appealed, and the U.S. Supreme Court said, yeah, you can't convict a white person of murder. You can't even charge them. You have no jurisdiction. Your laws don't apply because they're not part of your community. So, it's not as though this idea that you've raised quite clearly isn't valid. It's well understood. It's just in a different context. It's a them versus us kind of idea.
Yeah.
When it applies to them, of course the laws of China don't apply to us in the United States. Well, but of course our laws apply to all people in Mexico. It's just kind of really weird. It's inconsistent, but the point can be quite well made when you really start delving through these cases about what is jurisdiction. And, you haven't brought it up again on your show, but even John Galt would understand. Do they really think that the traffic laws apply to the Queen of England? Really? Queen of England and her entourage are going 150 miles an hour on some highway somewhere in Texas. They pull her over. Are the cops going to hand her the ticket? Really? Or are they just going to say, oh, sorry, Queen of England. Yeah, keep going. Everyone knows that. Well, they either won't issue the ticket, or when it goes to court, the first thing the representative of the Queen will do is just say, sorry, no jurisdiction. The judge will say agreed, and they'll just wave it on.
Right. It was like at the end of the movie. It was like at the end of the movie, Lethal Weapon, diplomatic immunity. And then he takes a bullet in the head. Of course, I do want to point out before the top of the hour break, though, is you're referencing Cook v. Tate, which is U.S. 265, page 47. And this goes right to one of the disagreements Juan has always had with me, that I have just, taken out of context what a citizen actually is, that it's a member of the body politic owing a duty of allegiance in return for a duty of protection, and that they're reciprocal obligations. So Cook v. Tate really brings this particular issue home, because what they're saying is, at the end, this is what it really comes down to. uh, the basis of the power to tax was not and cannot be made dependent upon the situs of the property in all cases, it being in or out of the United States, nor was not and cannot be made dependent upon the domicile of the citizen, that being in or out of the United States, but upon it, wait for it, upon his relation as citizen to the United States government and to the relation of the latter to him as a citizen. The consequence of the relation is that the native citizen who is taxed may have domicile, and the property from which his income is derived may have situs in a foreign country, and the tax be legal, the government having power to impose the tax. It's the relationship. It's right there in plain English, right, John?
Yeah,
and yet he will say that's that he will come. He will say that even though it is part of the ruling of the court, a legal ruling, it's completely inapplicable because all the court was doing was restating political philosophy. It's the ruling. It's a legal ruling. This is not dicta. That is the ruling.
Yeah.
And so my position is there's no evidence because it's even based on his own statement that my physical presence doesn't prove the laws apply. And he had said that it's power. And I'm saying that no amount of power can create those reciprocal obligations. And if you think you can use force, aggression to create power, obligations of allegiance and protection, I guess the government schools have done their job. They have conditioned you well to ignore basic principles of right and wrong.
Yeah, I mean, I can follow up on a whole bunch of things in relation to that, but there is you see it more, or I saw it more when I was outside the United States, and when I was in Turkey, for example, I would ask the kids. I said, well, are you a citizen? And they would say, yes, we are. And I say, but what's the name of the country? And they'd say, well, it's Turkey. I said, well, but what was the name of the country in 1917? And they said, well, it was still Turkey, but we were part of the Ottoman Empire. I said, well, what did the land change? What happened? And they, no, there was a war, and there was this, and I lived in Bosnia. I'd say the same thing to Bosnia kids. What? Yeah, what happened in? One day it was Yugoslavia, and the next day it was Bosnia. You had to go get a new passport. You had to go to, and they said, yeah, we did. And I said, but who are you declaring the people in charge? What's going on here? It's just kind of, how haphazard is it? And so you can really get a good look. Even when I lived in Mexico, I would, the kids would say, well, what are we supposed to do? We can't do anything. I said, well, there was a revolution in 1810. There was a revolution in 1910. Things don't stay the same forever. So, we should kind of hold out hope to say we can start to explain to people, as you would say, basic right and wrong or human decency, and start to get people to scratch their heads and say, well, all right, just because you say you're in charge, or just because other people said you're in charge, like Spooner, doesn't mean that I have to just do whatever you want. That doesn't really follow. As we said in grade school, right? Who made you in charge?
Yeah, I got to say, but are you going out of your way to live in such dangerous areas?
Well, Mexico, I'm telling you, I just read again what it was in the city of West Milwaukee. The cops were doing a safety or a secure visit or something to check on someone. And they end up killing him. Just, they tased him to death, right? They wanted a safety check, see how he was safe. And they made him safe by tasering him to death. I have a daughter, she's going to be 12 this summer, and she'll be coming to school here in China. Because in the United States, you go to school and there's a cop, the cop pick you up and slam you to the ground, or the cop will hit people, or it's just, for me, the United States is an extremely violent place. Had a cop pull a gun on me because I was avoiding his speeding up behind me. I literally moved over 2 lanes so he could cruise on by me. He didn't have his emergency lights on. He didn't have his headlights on at 10 o'clock at night. And I saw him coming at a high rate of speed, swerved over. He ended up pulling me over and pulling a gun on me. And I said, why are you holding a gun? And he said, you know, because I was outside of my car. And this was 2004, you know. And when the other cops showed up, they said, oh, we're sorry, Dr. Jones. Do you realize that Officer so-and-so had a gun pulled on him last week? And I said, well, maybe he shouldn't be working right now. You know, these guys are just under high stress. They think everyone's the enemy. And in other parts of the world, in Mexico City, cops walk around with machine guns. And they will wave hello to you. They will pose and take pictures with you. They will buy you lunch. They will be extremely friendly because they don't see the public as the enemy. And in the United States, the converse is true. And if you don't have a uniform on, you're the enemy.
Yeah. But for all those machine guns, journalist is still by and large the most dangerous profession in Mexico.
Well, you know, they're silly at one level. They're writing about the wrong thing and complaining about the wrong thing. In Mexico, you know, if you go, it's kind of like the prohibition of alcohol period in the United States. And these journalists are going the wrong way. They keep saying, well, these bad people are selling alcohol or selling drugs. And instead of saying, well, I got a bunch of bad laws and government people just skimming off the top. Why don't we eliminate these laws, eliminate the problem? They don't say that routinely. They do not. And when I was in Mexico, I always talked to taxi drivers, and I always kept saying, well, you know, shouldn't the drug laws be eliminated? And they didn't really agree with that necessarily, but they all agreed that the people in the military and the police were making money off the drug dealers, you know, or working for the drug dealers.
Oh, sure.
So they understood that. So it wasn't dangerous in that sense for me because, you know, I'm not a drug dealer. So I was on the outside of that. And Turkey, I did up leaving Turkey. That got crazy. I ended up leaving that place. And the university where I worked got shut down, which ironically had no affiliation with the CIA, but the government declared it had an affiliation with the CIA. So I had to get out of there.
Gee, well, I want to get back to this because I do disagree with you on another point that you had in here.
Okay.
And he says the main retort you could have said is that we cannot prove a negative. That is, we cannot bring evidence to prove that the laws do not apply to us or anyone.
So just to reiterate what happened, Juan Galt kept saying at the arraignment, you, Mark, you know, your people who listen to you, they're not bringing any. You're not bringing any evidence, and you have to bring evidence at the arraignment in order to rebut the rebuttable presumption that there is jurisdiction.
Right.
And I think no, it's literally impossible. But if you say it is not impossible, go ahead. What do you think?
Well, the 2 points, and what I did raise with him, and I did actually address both because it has to do with the power. But the first part of it is there's no need to present rebuttable evidence if evidence proving the claim has not been presented.
So been presented, yes,
right.
That's true.
So,
but again, I would say that's still not proving a negative. We're not proving a negative. We're just exposing that they haven't proved their claim,
right,
or they haven't even asserted it.
Well, right, and that's why I leaned harder on that, you know, more on that argument, because it's no different than if you and I file against the Internal Revenue Service and they file a motion to dismiss. I mean, it's not going to have any evidence, and they're not going to controvert the facts. All they're going to do is argue there's no evidence, that there's no jurisdiction, and they don't have to present contrary evidence. They just have to show you have failed to show jurisdiction. So it's the same thing here. And I did discuss about the force, and you could do that because they're not. This is something, Misty, you just will not accept this. They are not creating a rebuttable presumption on behalf of the prosecution. That's not what's happening. We could easily show, at the arraignment or during, you know, right before trial, we could easily show, because of the force and that the power that Juan talks about, and that all they have is a prison system, and we can prove by that those facts show their claim of that their laws apply is nothing. But the fact remains, as far as the practical application of all this, John, is that the judges are not a lot, or they're not saying that there's a rebuttable presumption. They're saying it's the way they act, and in practice, it's irrefutably true.
Irrebuttable.
It's irrebuttable, and that's why, because that's another point that I disagree with you on, and we'll get to that in just a second. That's why they don't allow us to raise the issue. That's why they just reject it outright. That's why they'll say gobbledygook, or they'll say it's legalistic gibberish. Even though just this past week, I've had more than one IRS, another tax agent, admit that questioning somebody's factual burden, or even just pointing out that they don't have sufficient facts, is not a frivolous argument and can never be a frivolous argument. So that's why I disagreed with, we can't prove a negative. I believe we can, by showing that the only support they have for their laws applying is a prison system.
Yeah, but
I guess it's more as we're showing that the argument that they're making has no merit. Not that I'm necessarily trying to, to prove the negative, but I think it's really the same thing. I'm able to prove their claim that the laws apply isn't true by showing the contemporary and historical evidence.
Yes, that's quite clear. I'm sorry, I found the citation. If people, again, if they're interested in looking at these larger issues, because I addressed citizenship on the broad picture and brought up a lot of cases, again, based on your material. So there's a real academic article written by a real law professor out there. If they just search John Jones Bill of Attainder, it should come up. It was from 2013. It's in a journal, in International, I think it's International Social and Economic Sciences Journal. But that's where I discuss, again, these issues that you brought up. I go into the historical cases, looking at American Indian law, look at other things. There's another famous international case. It's called the Nautenbaum case. I don't know if you've ever addressed that one. Do you know that case, Mark?
It's not jumping out at me.
It's an international law case, and it was a guy, and this we like to address the larger issues that make it more clear to people. Here's a guy who was born someplace in Germany, but lived basically his whole life in Guatemala. And during World War II, he went and paid for citizenship in Luxembourg and the United States. And I probably think United Fruit Company and the Dulles brothers and George Bush were involved. And they just told the government of Guatemala, go seize all this guy's land, go seize everything he has, because he's an enemy of the state of Guatemala, because Guatemala is an ally of the United States in World War II, and he's German. And he said, I'm not German. I'm out of there. And the Court of International Justice, or whatever it's called, the International Court, they end up saying, no, he is still a citizen of Germany, because he has a relationship with them, and he's really not a citizen of Luxembourg because he doesn't really have a real relationship with them. And here was a guy who did everything he can to escape the Nazis, escape Germany, and you had, so-called people of international law, talking about truth. They said, we don't care. You're still a slave to whatever organization we declare. I mean, that's how bad it is in terms of what people will say, whether the laws apply to you or not, or whether you're a citizen or not. You can't escape it, that their declaration that you're simply born a slave. That's really in the back of their mind, that you're just born a slave to someone, and we just got to find who your owner is, and we say, then therefore laws apply to you.
Well, that's why
that's, I think,
yeah. Well, so I'm sorry. That's why they don't. I haven't seen a case in past like 1977, 1978 that recognized res nullius. They instead of recognizing res nullius, that you're the property of no one, they just call you stateless. And I prefer res nullius. That to me, that's more to the point. I am not your property. And where is the evidence for this damn relationship? Just like and make no doubt, the Supreme Court, they did state that it was a presumption. It is that power in its scope and extent, it was decided is based on the presumption that government by its very nature benefits the citizen and his property wherever found.
Yes.
See,
Yes.
where is the evidence to support the presumption, or that and I would be happy if it was a rebuttable presumption, but when they hold it as irrefutable, so that this is why they say it's gobbledygook, and why they'll say it's legalistic gibberish, or they'll start screaming like an autistic child, frivolous, because they don't want to address the fact that their claim has no merit, that it's literally do this because it's true, because we said. I actually had an IRS agent tell me the other day, Robert Jones told me point blank, the Constitution applies because it says so. And I said, is it magical?
Yeah. And it doesn't say so, right?
Well, he says,
can
well,
I add?
Yeah.
Well, clarify that point. I don't think the Constitution says it applies to people at all.
I think the 14th Amendment does, to a degree. It's not as explicit as this IRS agent thinks it is, but the 14th Amendment has been used as allegedly evidence that the Constitution applies. Because
and if we, just to go on that point, and I've said this to people, I've had to explain it ever since learning your material. Just because I tell you, Mark, that you're a member of my club and I'll treat you a certain way doesn't make you a member of my club. It just means that's something I said about you. You know, that's a little bit different. The last point I guess I want to share with people, and I want to encourage people across the United States or wherever, because you've had people obviously succeed in other countries, is to create a little club. And I had to create a club. Years ago, I called you and I said, hey, I got a call from someone from the North Carolina Bar Association, and you checked them out and said it was a cop. And they said, well, we think you're practicing law without a license, you know. And I had created a postcard, and I went down to the courthouse and I handed it out, and I said, you know, get help with getting your ticket dismissed. And I put my phone number and email on there, and I left them around. And so obviously somebody picked one up, some prosecutor or something, and they reported me as a bad actor or something. Now later I got a letter from them saying, well, they decided that they were going to not investigate me. But I very quickly started telling people who asked for my help that we're going to say we're just in a club. We're just researching the laws and talking about law, and we're a peace and freedom club, you know. But I really encourage people to do that. You go to the public library, you can use space there. You know, you can go to a local law school, go to any university or somewhere, but just go to the courthouse. That you can find a list of people who either have charges against them, tickets against them, what have you. And I would send people out letters, or I would just stand outside when they're lining up for the cattle calls, and I'll say, hey, is anyone here charged with a ticket? You know, why don't you either, you know, tell them you want a continuance, or plead not guilty and don't take a plea, and you know, why don't you come to a meeting on Wednesday night at the local library, and let's talk about getting your ticket dismissed. And that's when I would do a quick little, you know, 15 to 20 minute presentation with some of your material. And I would say, hey, there's a guy out there who's done this. People around the country have done this. They have tickets dismissed. There's a simple template, you know, and I was there to kind of shepherd them the way you do, you know, edit their documents, what have you. Like I said, I added a few more, it made more explicit your more motion to dismiss in some parts. But again, it's using your material. You know, you've done all the background work. And I think, you know, the more we tell people, the more we share these ideas, you just kind of create that little monkey wrench and getting it out there and really kind of pushing the point, because people will start to agree, hey, wait, something's not quite right here. You know, people are being forced, and you know this, there's a whole debtor's prison kind of going on in the United States, where people get charged with not having insurance for their car. They get charged with not getting their registration. They get a speeding ticket or something and don't pay it because the court costs. In North Carolina, for example, the state legislature changed the court costs from $20 to $220 overnight.
Yeah.
And this is, they need revenue.
Yeah, absolutely. But I'm sorry.
Go ahead. Well, then, you know, what happens is people they'll go in and they'll say, and they'll tell them, well, okay, we'll give you a payment plan. And we're talking about poor people who either don't have a lot of money, don't have steady work, or don't know how to figure out their lives very well. And in 3 months, they get a letter saying, there's a warrant for your arrest because you missed a payment. You didn't pay $50 in this month. So we declare, we're the state, we're gonna spend $1,000 a week putting you in a box.
Yep.
The logic of economics makes no sense, but they'll do it. And if we're telling more and more people, if we're arming them with a simple defense that says, can you please tell me who's the person who has the facts on the personal firsthand knowledge that the laws apply to me? Just tell me who the person is. And then after you name the person, just tell us what the facts are. It will slow down this onslaught. It will just slow it down enough that people can start to break out of that trap. And I think that's a necessary thing to do.
Yeah, you just have to watch for infiltrators. So I definitely recommend not just having a loose network of people that are, like we have on the No State Project Skype chat. We are at the top of the hour, the second hour of Anarchy Radio. So I just want to announce back, to the LRN listeners, of course, glad you're with us. This is the second of 3 hours of Anarchy Radio. We're talking with John Calvin Jones, who is a law professor, and he's joining us in China. So I don't know how much more time you have, but 2 other small points here. You stated that we can concede that one was correct on one question, namely that the cop per se does not have the burden to present facts proving that the Constitution and laws apply. Nevertheless, some witness for the prosecution must. I disagree with you here as long as the police officers are law enforcers and are given a gun and a badge to go out and enforce the laws as if they apply to everybody, and they're writing tickets and they're making determinations of probable cause and they're making determinations that they have jurisdiction. Because of that, I'm going to have to disagree with you on that point.
Right. Well, I was thinking about what he was saying to you, and he always had a quick little quip, oh, that's not the burden of the police officer, just like any other witness. Well, obviously the police officer isn't just like any other witness. Usually the police officer is the only witness, the police officer is a complaining witness, but they're not a complaining party. And as I would say to Juan Galt, ha ha ha, yeah, the police officer doesn't have the burden, but somebody does, and the police officer is the only witness, then that's your witness who does have that burden. But per se, in name, that police officer didn't have the burden in the court procedure. I know, of course, what you're saying. I agree with you completely. But for argument's sake, I think we can simply have a simple retort to Juan Galt and say, all right, funny man, there's got to be some witness who says something about jurisdiction, and he would concede that.
Yeah, I think to be more accurate here, when it's just a police officer and he's prosecuting the case, it's his burden to prove that. However, the prosecutor has to, of course, like you wrote, he has to rely on that police, because the police officer made the statements and signed the complaint as the complainant. I know he's just representing the complaining party. So he is on the hook. So so if the police officer doesn't have that proof and he made those and it was on speculation, then obviously the prosecution, whoever that may be, cannot make their case, and it should be tossed out, of course. So, and just like with the IRS, yes, I'll concede that, yes, the prosecution with the IRS, obviously the prosecutor has the burden of proving every element beyond a reasonable doubt based on the testimony of competent witnesses, which that's going to be it's always going to involve an IRS agent, someone like Richard Wallen, who is basically the scum of the earth, who has to then testify with personal knowledge and facts that prove his allegations that led up to the prosecution. Yeah.
Now, can I just going on the tax thing, because I know you've helped people there. Maybe you know more about who was that guy in Connecticut who ended up going to prison? And he died in prison. His son's the investor that has a brokerage house outside the United States. Oh, you know this famous guy. He's always on Max Kaiser's show. But you don't know. So, well, he wrote a book in the 70s and he said the IRS didn't have jurisdiction and he got arrested. And
Irwin Schiff, right? Yeah, Irwin Schiff.
Yeah, Irwin Schiff. So what? Did you ever read his appellate briefs or anything? How did he challenge jurisdiction, or did they ask the prosecution to show jurisdiction, or did they just kept saying that the laws didn't apply, or
I don't
just the slavery argument?
I don't remember him doing that. I don't remember challenging jurisdiction on the same grounds that I would, that the prosecution doesn't have evidence to support that. And a lot of what he did was legal interpretation, and
yes,
just not a good way to go, obviously.
Right.
So.
And I think that as a last point, and I'll let other people talk to you today, is what you've said over and over, and because you said it from personal experience. There's a difference between legal interpretation, which I think what Juan Galt is focused on, and simply asking for facts in support of their claim. And you have rightly told people, we cannot go into court and say, here's what the Supreme Court said, because as you gave the famous story about using Brown v. Texas, the judge said, well, that's your opinion. That's your interpretation of that ruling, that case. And Juan Galt kept saying that, every case is different. Every case is different. Every case is different. Yes, but the procedural aspects of the case aren't different.
Yes.
They're not different. He kept saying every case is different. No, the procedural issues aren't different because they're trying to be fair and they have a system of procedural rules. Those don't change. The burdens created by those rules don't change with the prosecution. And so he was just, like I said, he's just bringing up red herrings over and over and over again.
That was one of the worst.
At some level, he was just trolling you. He was just trying to get a rise out of you. But he sounds so serious. And when you gave an example of something that responded to him, that answered a question, he said, well, that one doesn't count because it's anecdotal. As if everything that happens when we talk isn't anecdotal. It's all anecdotal. Of course, you have posted real documents from real cases where the judge said, okay, dismissed, or I like that one in Ohio where they got the ticket dismissed and no evidence, right? You have that, you posted that one with no evidence. So
yeah, I mean, I could have been a douchebag also. And when he started rattling off his resume, and I was involved in Heller. Anecdotal. Give me something solid. Yeah. Oh well, Columbia. I forget the Hobby Lobby. It's another anecdote. Give me something serious. That was one of the things that probably was what really started setting me off with him. And yes, he got under my skin. I fell for the dumb lawyer trick. I'm not calling him dumb. It's just a stupid trick that lawyers do to get you flustered. And after an hour, it had to turn around and say that I am cherry picking or misquoting or taking out of context the Iqbal case, which was based on Twombly and other cases, that for some reason, Rule 12B, they're stating that there has to be facts, not just legal conclusions. That only applied to Iqbal. It doesn't apply to Rule 12 or Rule 8, rather, the rules of pleading. That's like, are you out of your mind? So you're telling me that Miranda versus Arizona only applied to that particular case? Then why are they reading people their rights if Miranda versus Arizona only applied to Miranda? Yeah, let me bring the feed back up because I am going to have to connect the caller line soon anyway. But I don't think we're at a break yet. So I know you got to go. I appreciate the time. Any last words?
Just, I encourage people to get your information, to support you, to share with their friends and family. It only takes that kind of one person in your family or in your small circle or larger Facebook circle or whatever circle you have. Take one success to really start those dominoes going. And you have plenty of evidence of success. So, people ought to stick their foot in the water and really resist the oppressive system. All the state governments, all the local governments have to try to extract fees. They cannot exist otherwise, and they're existing on our ignorance. That's it.
Yeah. Well, I appreciate the call. We're out of time for this segment, but thanks so much. And send me a link for that document.
Yeah.
And I'll get that posted. My name is Mark Stevens. You're listening to the No State Project here on LRN.FM, the Liberty Radio Network. We'll be back with your calls in just a few moments, so don't go away. Jenny? I'm sorry, what did you need? I can handle that.
Allowed to wear stuff like this to work.
If you're scared, don't do it.
Find my work pants.
Right. Yes, welcome back to the No State Project here on LRN.FM. I want to thank John again for coming on. Hey, and I'll throw this out. Maybe one day we'll get John and Juan on a call together and sit back and watch the fireworks. Before I bring Bao on, I just want to address Misty continually going at it. Iqbal was just changing the finding in Twombly. It had nothing to do with the traffic ticket, which is sufficient under Rule 8. I didn't mention that it was exclusively for traffic tickets. However, when I have discussed that in particular is pointing out that the complaints at the IRS, when they file a civil complaint for the enforcement of an IRS summons, they only make allegations. They give you no evidence to support the allegations, the important allegations. So it is appropriate there. Most traffic tickets, I understand, are not going by the civil rules of civil procedure, which is why I mentioned on the last show, you typically can't do a cross complaint or a counterclaim because they go by different rules. But they do have to have a prima facie showing. That doesn't change. There has to be evidence of jurisdiction, whether it's a traffic ticket, a parking ticket, or a murder indictment. They still have to have the evidence there. So it's important what the court is saying in Iqbal, that legal allegations may form the framework of a complaint, but they must be supported by facts. That whether you're looking at Iqbal or not, that has always been the standard. And once you depart from that, that's actually, if they did depart from that, maybe we can get some complaints in against these judges and against these prosecutors because they just throw the rules out. So anyhow, the point is there has to be some fact. I'll repeat this again for Misty. To have prima facie evidence, your prima facie evidence burden, to then have a rebuttable presumption created, you have to have facts, evidence that has some slight chance in proving the claim is true. To prove personal jurisdiction, you have to show that the Constitution applies to me because I'm physically in Phoenix. That's the claim. I didn't make it up. One didn't make it up. And I'm not saying you're making it up. That's the way it works. Come on the show, Misty. You're more than welcome. Does my physical presence in Arizona prove that the Constitution applies to me? And the answer is a resounding no. Because it doesn't meet the slightest chance requirement. My physical presence doesn't prove that. Does my not having a driver's license do that? No. So unless you have actual proof to show that there is some slight chance that my physical presence proves the Constitution applies to me, they're not meeting the burden even on a parking ticket. So okay, hopefully that it's not going to take care of that. But for people who are open-minded and want to critically examine this, that will make that should be enough. But if anyone disagrees, 218-632-9399. The passcode is 2020 if you want to join me, and you may do so. You're welcome to. He's been on the show before. Hopefully we got some good news going on here. We got Bao from Texas. Oh, I got to unmute you.
It's Bo.
I did it.
So
different guy. Okay. Bo in Austin. Sorry.
I've been on the show before, Mark, and I'm doing some research into the esoteric principles that all of this gravitates into. Well, first I would start by saying that which is created to serve us can end up ruling us. I don't know if you've ever heard that.
I've heard something like that
statement. And I think what happens ultimately is that if you go back in history, let's say 18th, 19th century, the ruling class was just that, the people with all the money and the power. The other people that really mattered at that point were people who owned land, because it was an agriculture society. And with land came, livestock. And I'm not going to go into the straw man thing, but the 14th Amendment really kind of does make us all basically livestock. And the borders on the maps really separate not countries, but farms. You know, and the reason I say this is because there's different management processes for livestock, and I'm going to call it state capitalism, communism, socialism. And this is all basically when you walk into a courtroom and the judge and the prosecutor and the clerk and everybody just assumes, well, of course we've got jurisdiction. You're physically located here, and therefore you're within you're in the farm. You are in the farm, buddy. And you know, a lot of the rules that we've been discussing about prima facie and all that those are useful, but there's always that brick wall that we run into. And you've so eloquently pointed out, not saying apafangul, but by saying what evidence do you have that just because I'm physically located in this area that your laws apply to me? And there, you know, and that's what it is. It's basically, well, they don't want to say it, but it's like, hey, look, since the dawning of, you know, of the age of whatever, Pisces, you know, you are basically livestock. And I wanted to bring up one other thing. And
okay, wait, Bo. Well, hold on. Wait, keep that thought. Do like I do. Write it down. The thing is, all that you're saying is true about, you know, they see us as human resources, you know, livestock, you know, the tax farm, as it's been called for quite a few years. All of that was true and will be true whether there's a 14th Amendment or not. There were, I mean, look at early American history, you know, Shays' Rebellion. They didn't want to be part of that tax collecting district. And, you know, all the way back then, you know, the tax farms are what they continue doing after they threw the British out in Massachusetts, for example. And then after the British, you know, by the time the start of the war, all the Americans did that weren't loyalists, the rich landowners that were, you know, doing this, they just took over the old tax farms. That's all they did. And that's the same thing as when Rome would go in and conquer. Let's say when Rome conquered Turkey or, you know, Palestine, they took over the tax farms and continued the, you know, and then they put, like in Palestine, they put the Jews in charge of collecting from the Jews, and that's the way it's always worked.
You couldn't even vote. You could not vote unless you were a landowner during the period of time we're talking about.
Yes, a certain amount of land. You had to have a certain amount. You had to be pretty well off, and yes, you had to be white, of course.
And it's my belief that this stigma really has just been attached to the inculcation or the way that we indoctrinate.
Well, Bo, I got to put you on hold. Just hold on. Keep that thought, Bo. We're up against the break. No, I'm not going to go smoke a bowl, but I guess if you know, in the central time zone, you're probably getting busy. But we'll be back with Bo in Austin in just a few moments, and we'll be back with your calls. So, hey, don't go anywhere. I'm not going to mute the feed for the YouTube. Welcome back to the No State Project, live from LRN.FM and streaming on my YouTube channel, No State Project. It is May 5th, 2018. I'm glad we got new people. Maybe we'll get a record today for the number of people that are listening in. So I think we definitely have a few new people because somebody is, I think it's somebody, Mike or someone is asking, what's with the big G there in the background? Nothing nefarious, guys. You tell the guys who come over from InfoWars, my wife's name is Gina. So yeah, it's not some big grand conspiracy. If I was controlled opposition, I'd be at Libertopia right now broadcasting the show, but not today. But I want to get back to the calls. We have Bo in Austin. Bo, welcome back to the big show.
Hey, Mark. Yeah, the G does not stand for gangsta.
No, I think it's either Gina or somebody might brought it up on a few shows back that it's actually for Guido since I'm Sicilian. So we'll use it for both. It's for Gina and for the Guido.
Yes, sir. So I wanted to bring up one point. I've heard you mention time and again where in some some of your conversations with judges and prosecutors, they will say, what you're arguing is a philosophy. Do you recall that?
They don't let me forget it.
Yeah, right. And so I wanted to bring up that statism is not a philosophy, and it doesn't originate from historical evidence or rational principles. It's really kind of a management process for livestock or serfdom, if you want to be accurate. And so it also statism, it ends up being an ex post facto justification for human ownership. This is why they have so much power. I remember Juan Galt saying, "Oh, it's power. That's the power." So that's basically, what is that? Human ownership. If you can do business at the barrel of a gun and get away with it legally, then that kind of connotates some sort of ownership, I think.
Well, ownership is control over property. So in a sense, yeah, it does get it. Yeah. The reason why people will say, like Juan Galt will use the philosophy is to negate the discussion and the challenge. And that is not something that actually comes up in court that I can remember. No judge has ever said to me, "Sir, you're arguing philosophy," because I said, "Well, objection. I'm asking a question. Has the prosecution met their burden?" Yet, it's not a matter of philosophy. You black-robed, cross-dressing idiot. The whole thing is done just to shut down challenge and divert attention. So people like Misty will give credibility to what Juan is presenting. Like, don't reach, pull that curtain back. Don't ask those questions. That's why I use that picture with the cow for I am jurisdiction and thou shalt not challenge. So for those who haven't heard, and I'll let you just bear with me for a second here, Bo.
Yeah.
His position is this: if a tax agent or some bureaucrat is coming after me and they make a claim against me that their laws apply to me, and I challenge that and ask for the evidence that their rules say they have to have, if they give me an opinion and I object and don't accept a non-responsive answer, then all of a sudden I am reframing a legal challenge into one of philosophy, and that means that the one making the claim doesn't have the burden. And that's why he tries with this ridiculous claim where he says you cannot take basic principles of logic and use that in court, where he asked for evidence that you could. And I said, well, in a criminal prosecution, the burden is on the accuser. That's directly from basic principles of logic. So, and of course, he said that wasn't evidence. And all right, whatever, we can experience that. But that's the whole basis. The philosophy thing is just to shut down the argument and to shut down the challenge. That's all it is.
It does. And the opposite of ideology is not a different ideology. It's clear evidence and rational principles, which you bring up through logic. And Juan Galt was like, "No, you don't understand. You can't use logic because that wouldn't be fair." You know, and it really it is esoteric in that it goes back to the idea that that this system that has been said we the people created ends up ruling us. I mean, there is in science fiction, now we're getting to the point where we're like, oh, we're making really good computers and soon they're going to start ruling us. They're going to take over. You know, they started out to serve us, and then they're going to basically go, you're not smart enough to handle this yourself. Let us go ahead and take care of it for you. And this is really rooted in the idea that you know, citizens are or not citizens, but people are livestock, and the ruling class has that. You know, that's where they get their power from. Is basically ownership.
There is a line from, I can't remember the name of the song. This is killing me. It's from System of a Down, and it's one of their best songs. And the line is, they're talking about war, right? And the line is, why do they always send the poor? And that's right, because it's one thing to be you know, because we're all considered livestock, but more so if you're not wealthy. So if you don't have money, so why do they always send the poor? Because they're the cannon fodder, and they have been from time immemorial, and they always will be until we throw off these shackles and get to a stateless voluntary society without a ruling class. So yeah,
you know what? I'm a vet, Mark. I've served in the Gulf War, and back in those days, you know, if you were a young person, you could use the military either to pay for college or it was, you know, there were some judges back then that if you were a bad boy or girl, they might say, hey, you're going to have to do a couple of years in the military. Well, now in 2018, it's not so easy to join the military anymore. So I don't even know. I mean, it really isn't. If you've got, because of our criminal justice system, you know, if you get busted with a felony, it's harder and harder to get into the military. So it's you know, the climate is changing in many ways. It's going to be interesting, but there are a lot of people awake. You mentioned earlier that this may be the most listeners you've had in some time. And people are waking up, and I'm watching their comments, and people are starting to push back a little bit, which is healthy. That's why I call in every once in a while to go, keep doing what you're doing. I'm glad those two guys in Peru are paying for your show or whatever it is. But you know, you're doing great, and we love you, and you just got to keep speaking it. Last thing I wanted to mention real quick was, have you heard of a guy in Texas, in Austin, I believe, and his name's Eddie? He does this thing called Tao of Law, Eddie Rodriguez or Eddie, anyway, and he's dissecting Texas law, and basically he doesn't use the idea that, you know, you need evidence. He's just using the codes to crack the code, basically. But I didn't know if you had heard of the Tao of Law or that site.
It sounds familiar, but especially for people who are new. I think someone's saying it's Eddie Craig. So yeah, I thought that's what I was thinking too.
Yeah, Eddie Craig. Yeah,
and just more important than that is that it's BYOB, is the song from System of a Down. So I'd play it, but then I'd have to pull this video down because I get hit with a copyright strike. So that's why I'm not doing that. But the problem that you have, again, if you're new to this is what you want to, you know, keep in mind. You have different burdens that you have to prove. You have prima facie, you have beyond a reasonable doubt. You have different burdens. You have shocking the conscience of the judge. And doing the whole thing of legal interpretation is a very, very bad way to go, at least in this particular arena. I'm out of time, so I got to let you go. I do appreciate the call, Bo, in Austin. I'm going to finish this in the next segment, talking about why we don't want to use legal interpretation, why that is a really bad way to go. And then we'll get back to your calls. We have Rick in Oregon also coming up. So I appreciate everyone's patience. We'll be back in just a moment. Yes, welcome back to the No State Project, live from the fortified compound in Mesa, Arizona, for May 5th, 2018. And get to the calls in a bit. In just a moment, I want to just finish what we were going over, why we don't want to use as a defense against their baseless claims is to come out and try to use legal interpretations that, such as right to travel, stuff like that. Because like John mentioned, the thing that got me, why I stopped doing that, was all those years ago in a traffic case, Brian Strong, who is still a practicing attorney in Mesa, Arizona, who was the initial inspiration for the cover of Adventures in Legal. I've included his picture in some of the videos. I read directly from Brown versus Texas. I was not interpreting it. I wasn't saying what I thought it said. I read it directly. I read the ruling directly into the record. And this damn lawyer snapped at me, "That's your interpretation." I'm thinking, I didn't interpret anything, you idiot. That's what it says. What do you think it means, you... that's what you get from lawyers. You never get a straight answer. Everything's interpretation, but only theirs is correct. Not because I got a prison system. So we don't want to use legal interpretation, because the burden of proof on an abuse of discretion is to show that they are clearly and dead wrong, that there aren't other, that it's in opposition to the plain meaning of the statute. And that's when you see Gitlitz versus Commissioner back in 2001 or 2002, the United States Supreme Court, in a rare show. Now we almost have the maximum people. So we only need a few more to get the maximum for the YouTube stream, not the LRN stream. What they did was they reversed an IRS ruling upheld by the Court of Appeals and the tax court, who, of course, were screaming frivolous at the top of their lungs, saying that the courts and the IRS's interpretation was in direct opposition to the plain meaning of the statute. It's a very high standard to get. And when you have law libraries full of conflicting legal decisions to the one, or legal opinions or interpretations that you are bringing forward, you cannot win. They're going to look at what the dead lawyers have said, and they don't give a damn about what your interpretations. And I'm not saying that your interpretation is wrong. It may be very logical and really what the statute is saying. They don't care. Their job is to farm us. We've talked about this. Bo, we haven't spoken actually in those terms in a while, but we are livestock to them. This is not just a matter of, oh, they're protecting and they're providing services. No, we are human resources. We are there to fill their bank accounts. We are there to make it possible for people like Juan Gold to charge obscene amounts of money to do what he does, and to keep people like myself out so it thins the market. But they were able to have a monopoly. So it's the burden is far too high, and you're not going to win on legal interpretation. And if Eddie Craig and other people have gotten things tossed out based on a legal interpretation, show the evidence to do that. I'm not saying that he doesn't have things that are thrown out. I'm sure he does. But is it because his legal interpretation was accepted as opposed to the mountain of legal interpretation that the prosecution can present? I would say it wasn't. It's much easier to prevail when you show that the prosecution has no evidence, because when we go ahead and start doing things, now they're lying. We have a federal judge, Susan Richard Nelson, on record lying that somebody waived their right to a cross-examination when they didn't. Then we have the judge that I can't remember the name off the top of my head in California, who lied for the IRS, saying that we had made a naked, it was a naked accusation, even though there was a CD filed proving that we were just quoting the agent. Just lied and said, nope, no evidence. What was the CD, you black robe jackass? Yeah, jackass. So let's bring Rick on. He's been on before. Hope he's got a good news update. Rick from Oregon, welcome back. I know you've been patient there, Rick, but you are unmuted. I don't know what's going on over there. So we're going to try him at the top of the hour break, which is coming up real soon. Anyway, we'll see if we get that squared away. Okay. So the legal interpretation stuff. This is something that, because I'll tell you right now, and I did this live on a broadcast not that long ago, that people will use court cases and let's say with the right to travel stuff. I'm not saying there's any evidence that anyone's required to get a driver's license. I'm not saying that at all, or to get any kind of license. But yeah, I know. I already know that. So anyway, where was I? I'm talking about legal interpretation. See, one of the things that comes up with the right to travel stuff is so much of this right to travel stuff, people are just making up the quote, which is, all right, we're going to try this again. All right, Eric. Eric in Oregon. I know you're saying here that. Okay. Saying here. No.
Hello, Mark.
Okay. Saying here. Hello, Mark. No, it's not me. I don't think so. We're going to have to fix that at the top of the hour break. We'll try a Skype call.
Can you hear me?
We have a Skype caller. Which name were you calling from?
You just unmuted.
It's all right.
Something
happened to my call line. It's showing that.
I can hear you now.
I don't know.
The show's messed up.
That's not Mark. That's me.
What's going on there? So really odd.
Wow.
Not getting anything.
Are you on Skype?
No, I'm dialed in.
I'm going to mute them back up. Rick, no. Okay. Someone's asking, can't someone just motion the judge not to allow arguments without evidence, arguments based on speculation, arguments based on conjecture, then ask for evidence from prosecution? World War Wit asked that, and that's what we actually do. So what you're talking about, a motion for the judge to not allow arguments without evidence, it's called a motion in limine. I don't know what the Latin means. I forgot. It's not important. But a motion in limine is something that prosecution or defense can file to limit an argument. So if they're arguing without evidence, or if it's something that the judge has already considered to be so prejudicial it shouldn't be raised, they'll do that. So one of the cases that I bring up is the one in Wisconsin, which was in the making of a murder, the Stephen Avery prosecution. And what the prosecution team did, this is enough to show that the fix was in from the start. You're talking about a murder case that could have resulted in I guess it could result in a death penalty, but it was a murder case. And they filed a motion in limine and blocked the defense from presenting any evidence that showed that someone other than Stephen Avery committed the murder. Wow. So, and I would say in a sense, that I don't know if it's been technically done again. I say in Mike's particular case, because the prosecution didn't do this, it was the judge, the psychopath Larry Burns. He was not going. He had threatened Mike if he raised the issue of the applicability of the code in front of the jury, he was going to go to jail. He was going to be punished severely, and then they would appoint an attorney to finish the trial for him. So, yeah, okay, I okay. So that's what the motion in limine is, and it's easier. I think we have more grounds for something like that than if we have legal interpretation. So if the prosecution doesn't have evidence, that it's great. We have prosecutorial misconduct, and we had the motion in limine, as opposed to you can't really use that to stop the prosecution from arguing legal interpretation, because there's going to be a mountain of legal of precedent that he's going to be able to draw from. So it's just another reason why we don't want to use legal interpretation. They do not have any facts to support their claim. I don't care what anyone says. If they're claiming that the laws apply because you're physically in Arizona or Canada, they have to have proof. And your physical presence does not prove that. Oh, you was born here. That's the same thing as physical presence at one time. It's all based on physical presence. I'm going to fix the call line. And so we'll be back with your calls and more in the third of 3 hours of Anarchy Radio. So we'll be back in just a moment. So don't go away.
Hi, Mark. Can you hear me? It's Eric. Hi, Mark. Can you hear me? It's Eric. Hi, Mark. Can you hear me?
Skype caller, can you hear me? All right, Rick, can you hear me now? There's absolutely no input at all. No imp. Hello? Hello? That was odd. Hello?
Mark, I can hear you now.
Oh, he's
audio line.
Gee, I don't what the heck was going on. All right, well, we got a few minutes. So all right, well, I'm going to take a chance and I'm going to put you back on mute, and we'll be back in about 3 minutes, okay?
Okay, yeah, I emailed you a letter I got. If you look in your email.
Yeah, I'm not going to be able to do that right now because the way I have things set up, I have to shut my email because I can't turn the notifications off, and so I get them all through the show.
Okay,
but we'll be back in a few minutes, so just hold tight. Yes, welcome back to the No State Project right here from the fortified compound in Mesa, Arizona. On the Liberty Radio Network, LRN.FM, and of course, streaming live on my YouTube channel, No State Project. Appreciate everyone tuning in. Want to get back. I think we got it squared away. We have Rick from Oregon. Welcome back to the show.
Hi, Mark.
you had me going there for a second. I can look at the board and I can see there's no input. Okay, well, welcome back.
Yeah, it's actually Eric from Los Angeles, California.
What are you guys doing to me?
So I just had one quick question today. I sent your Demur judicial notice and Brady discovery request to the Napa DA. It's a criminal driving without a license case. They finally replied via mail, and they basically sent me what they're calling a pro per discovery release. And they're saying that I need to sign this release in order for me to receive any discovery. But they also said all victim and witness information has been redacted by the district attorney's office prior to the receipt. Is that proper that they can redact all the witness and victim information on my discovery request?
Well, I could see if a victim, depending on what kind of action it is, but the witness, no, they have to disclose who the witness is. That's some serious overreach there.
Yeah, because what happened is some vacationers in Napa were from out of town, some old people, and they kept putting on their blinker. They turned, and then they swerved back into the lane when I was passing them, and they hit the rear end of my Suburban. And nobody was injured. They said they wanted to call the cops. We wait 2 hours. The county cops showed up and takes a 2-hour report from them. Didn't take anything from me. And then 2 years later, I get this criminal driving without a license. I had showed the cop my New Hampshire license, but I have places in New Hampshire and California. So she said I'm driving without a California license. But there was no injury. There was no party harmed. If they claimed anything, my insurance actually paid for the slight damage on their vehicle because the cop found me at fault. So I don't.
We lost you. You see, you guys are going to say it's my fault on this, but I don't think so. Damn it.
What do you mean?
You broke it. Well, yeah, your audio just cut out for like 20 seconds.
Oh, okay. Sorry. Yeah. The only victim or witness I could think of is a person in a rental car hit me in the rear end because they were turning and swerved back in the lane. And there was a slight damage to their rental car, which my insurance later paid.
Right.
Because the police officer said I was at fault, even though they were turning and swerved back in. But is it true that they can redact that information? Because the person that hit me couldn't be a damaged party because the insurance paid for the rental car, which wasn't theirs, and nobody was injured in the accident.
No, in a situation like this isn't rape or something like that where the victim can, they have to give you the goods on the witnesses they plan on bringing against you. This is not a murder trial where they have to be worried for the safety of the witnesses. They have to give you that. So I would file an objection. Tell them no. I need the name of the witnesses, and if you're going to persist in this, at least tell me if yes or no. Do they have personal firsthand knowledge of the matters they're testifying to, including that just because I'm physically in California, your laws apply. At least give me that much.
Okay, and in this case, they didn't include anything about an accident. The cop just wrote up a ticket saying crossing double yellow lines and driving without a license. There was never any mention of it. And so it was just a traffic citation that turned into a criminal misdemeanor charge. So is the cop going to be the witness that they're referring to or the victim? You know what I mean? I don't even know who's suing me other than it says the state of California and the DA's name.
Right. Well, they're going to have to bring the police. The police officer wrote the ticket, right?
Yeah, so that would be the witness, but not the victim.
Right.
Yeah, this will be interesting when I go into court Tuesday to see what they say.
Are you going in? You have a trial on Tuesday?
No, Tuesday's another settlement hearing because I sent all your requests in, and the judge said 21 days to, they need at least 21 days to review. So he just keeps scheduling settlement hearings. And then there's another hearing the following Tuesday to discuss the motions that I put in from you, the demur and the judicial notice. So I'm not even sure why he keeps scheduling.
Well, at least you have an opportunity to confront the guy and say, look, you know, you try to get the name. Look, you have to at least give me the name of the police officer who wrote. Well, you already have his name, right?
Yeah, exactly.
So you want to just confirm that he is going to be called as a witness. Because the prosecution, like we talked about in the first hour with John, the prosecution still has to prove personal jurisdiction and subject matter jurisdiction. So he has to rely on somebody to prove that. And I don't know where he's going to go other than the police officer. And so I would bring it up. Who do you plan on bringing to prove personal jurisdiction?
Okay.
And then, of course, do they have personal knowledge that just because I'm in California, your laws apply?
And your demur, I should just go back point to point on that in the judicial notice and say, I need to see an injured party. There's no injured party charging me. Or is that after they deny me on the jurisdictional challenges?
Well, you know, that actually goes to subject matter jurisdiction, whether it is an actual adversary. Because, you know, even in California that they like to deny this, it's advertised anyway as being adversarial. And it has to, and to be adversarial, the Supreme Court tells us in that Poe versus Pullman case, there has to be an antagonistic assertion of rights. They have to be claiming that you violated a legal right of the plaintiff that resulted in damage. That goes to the corpus delicti, the act and the result, the loss, harm, or injury. So yes, they have to show that. And it's not even alleged from what you're saying. It has nothing to do with the accident. You said it's not even mentioned in the complaint, right?
No, they just said driving without a license and double yellow lines. Never mentioned any victims, nothing in the complaint. So they would have to file new charges, or can they just?
Well, no. Well, for the no driver's license, they're not going to be calling the other drivers to do that. They're going to be calling the cop, and the cop is now alleging, of course, and so that's what I would hit them with. So you're going to have the police officer testify that your laws apply and that I violated them, right? Can you say with certainty that he has personal knowledge of that just because I'm in California, your laws apply? Does he have personal knowledge of that? Hey, you might get some leverage and he might think hey, let's talk about a deal.
Yeah, the only deal I would accept is dismissing everything. I'm not getting a misdemeanor over driving without a license. I even showed her, the cop, my New Hampshire license when I was pulled over, and she still, you know, she's saying I'm a resident of California, but I guess if the cop won't even show unless we end up going to trial, which will take a long time the way this is going.
Well, they only have 180 days to bring you to trial.
From the time they sent the charge? Yeah.
So from the time they filed the charge. So I don't know how much time that's been, but hey, try to get some leverage on this prosecutor. You know, say, look, if you don't have any if your witness doesn't have any personal knowledge, then how do you go about? How do you plan on proving jurisdiction? This is if you are going to persist in this charge, after what you've just said to me, I have no choice but to file a motion to dismiss for prosecutorial misconduct, because you're obviously arguing against me without any evidence at all. I just put it to him point blank. You know, what if he did say to you, Mark, don't say that. He may have requested an extension. Did you ask for an extension or a continuance before?
No, the first time I went in front of the judge when I first received the notice, I told him I am challenging jurisdiction.
Okay,
and this is before I saw some of your videos. But I just knew that I had to challenge.
All right, well, hold on. Eric, I got to put you on hold for just a moment. We're up against the break. My name is Mark Stevens. You're listening to the No State Project right here at LRN.FM and my YouTube stream live in HD at No State Project. We'll be back with Eric in Los Angeles and the other callers in just a few moments, so don't go away. Yes, welcome back to the third of 3 hours of Anarchy Radio here on the No State Project. We got about 3 more segments to go, but I got something I got to get to. I'm all for dissent, but good Lord, do some homework prior to posting things as if they are true. This is the thing with case citations. But at least you should have you should read the case citation before you actually put it out on publicly as if what your interpretation is actually, we went through this. Somebody was making these wild claims, and I'm like, I'm on the internet right now. I could just copy and paste, and I can look up the citation and see whether you're telling the truth, whether what you're saying is accurate. But I'll address that. I want to finish with Eric. So Eric, I would recommend getting into the No State Project Skype chat and definitely working on doing the role playing for when you confront this lawyer in a few days, and hit him on the accusations that he is required to have evidence to prove. And if he doesn't, maybe you can also look. I think this should be dismissed completely because you have no evidence of this, and I will bring it up at trial if you force this. I will cross-examine your police officer if he's put on the stand over my objection. But if you're not willing to dismiss it outright and withdraw, can we get this so it's not a misdemeanor and it's a minimal fine? And maybe that, I don't know if that's what you're looking for, but because otherwise at trial, you can not only annihilate them, but you can show the other driver's license.
Yeah. And so if I get it reduced where it's not a misdemeanor, does the DA still get a win in his category? Because this is all about a win, right? Because the DA offered me a $47. He said if I plead guilty to the driving without a license, he'll drop the double yellow line, and it's $47 plus a $100 court fee. And I was just more disgusted at the thought of them prosecuting me criminally because I've never even been arrested. And I did have a license.
Yeah, they can, so he's already open to a deal. So after you hit him metaphorically, after you hit a few times where he's got no evidence to support his claim of jurisdiction and subject matter and personal jurisdiction, and that he clearly doesn't have a qualified witness, and he may do like Tiffany Castillo. I don't need to. Probably won't do that since he's already looking to throw you a decent deal. You may be able to get it, maybe get it dropped to where it's not even $47. Or maybe they'll look to waive the court fee or make it only the court fee.
Okay. And the one final thing, if you have the time, and I'll definitely try to get on the role play Skype chat. But Eric Wayne was given some advice on the YouTube chat about saying if they can't prove subject matter jurisdiction, they don't have personal jurisdiction. Does that mean, like with your demur and judicial notice, all those complaints they need to have those things in order to be subject matter? And then subject matter jurisdiction allows them to bring me as an individual to court? Because I don't understand the difference between subject matter and personal jurisdiction.
Personal jurisdiction is just the fact that the court has jurisdiction over you, or the police officer had jurisdiction over you to give you a ticket. Subject matter jurisdiction has to do with whether the court has jurisdiction over a case with that particular subject matter. So let's say the subject matter is traffic. They have, as long as there is a case, meaning that there is an act and a result, the violation of a legal right and damage, then they have what's called subject matter jurisdiction to then get, of course, the personal jurisdiction. If there is no subject matter jurisdiction, there's no personal jurisdiction. So, and that's why subject matter jurisdiction is so important, because it can't be waived. They can't say to you, oh, you waived it. No, you can't do that. They can lie and say you waived personal jurisdiction, but no one's going to believe them that you waived subject matter because you can't.
Okay. And so the cop thought they had jurisdiction because there was an accident. But since there's no injured party, they would need to prove I was conducting commerce.
No. No. The personal jurisdiction is based on one thing. If you're physically in California, their laws apply to you. That's it. And it's why they also call it territorial jurisdiction. Whether you're in commerce or not is completely irrelevant. Let's say you were selling hot dogs. How does your physical presence in California selling hot dogs prove the Constitution applies to you?
Because you're physically there.
How does my physical presence prove the Constitution applies to me, though?
Okay.
And to quote Juan Galt, it doesn't.
Okay.
All right. So give him hell on with Tuesday and let us know what happens.
Yeah, in a settlement meeting, should I be bringing up the points on the demur in front of the justice or the commissioner?
Yes.
Okay,
you want to
I should go through them point by point and say, I want written evidence that's sworn by oath. I provided a written document like they asked, and I want written evidence back. Just keep going back to that?
You don't have to say you need it. You just need them to disclose it to you. They can't disclose what they don't have. So whether you want it orally or written, they can't provide it. So instead of just be brief, look, where is the prosecution's evidence to prove personal jurisdiction that just because I'm physically in California, your laws apply to me? Where is it? Because I don't see it. And yeah, put the pressure on the prosecutor. All the attention should be on the prosecutor's claim. Where is the evidence for the prosecutor's claim? Okay, it should be your whole focus.
Okay, and I can read the demur and judicial notice.
But you don't need to read it. What you need to do is just to see where does the prosecution have the evidence to overcome point 1 or point 2 or point 5. You don't have to read it. Just ask for the evidence to overcome this issue.
Okay. Okay, cool.
All right. Well, good luck. Let me know. Let us know. Leave us a message or something on Tuesday so we know what happened.
Yeah, sure. Thank you very much.
All right. Appreciate the call. Good luck, Eric, in Los Angeles. Yeah, definitely don't. The prosecutors should be sweating. We're going to see. We have another Skype caller. What's your name? Where are you calling from? We're going to go through that again. Okay, we'll try to get them on a break. I have something here from Misty, who's saying a cop is prohibited from testifying about applicability of law, and she's giving a citation here as if this case actually says that. Now, I'm guessing here, Misty, you correct me if I'm wrong. I'm guessing you got this from Juan Galt, that he's feeding you this. It's Turabukchuk versus E.T. Simmons Construction Company, United States District Court, South District of Illinois. And I pulled up a copy of this. And what I'm going to do is I'm going to put it in the chat so people can see what it says. And I'm going to put that there in the Skype chat too, so you guys have a copy of that. And what I'm going to do is I'm going to read that into the, I'll read that online. And it doesn't mention anything about police officers. And it's talking about a specific kind of witness. So, Misty, you're dead wrong. And we'll bring that out in the next segment. So don't go anywhere. You're going to want to hear this, everybody.